Hi, my name is Robert Shelley with Chelle Law, and my law firm assists professionals with employment contract issues. Today, I'm going to talk about, is a letter of intent for employment binding? So the short answer is probably not. Kind of how the process would work is when a professional is looking for a new position, the employer may state, before we give you an employment contract, we'd like you to sign a letter of intent, also referred to as an offer letter. And then in that letter of intent, it's going to outline kind of the main points of the employment relationship. So normally in a letter of intent, you'd have the term of the contract, so how long it lasts, maybe how it can be terminated. If it has without cause termination, what's the length of notice needed? Certainly, it's going to have compensation details, base salary, productivity bonuses, commission percentage. That will be listed as well. Maybe a brief description of the benefits. And then if there's a non-compete involved, if it's a healthcare contract, maybe some details about the malpractice insurance. So kind of really quick bullet points of, all right, this is what we expect the employment relationship is going to be. And so at that point, there may be some negotiation between the professional and the employer. For instance, if the professional wants a higher base salary or a higher percentage of collections or whatever it is, that's the time to negotiate. And then once, an agreement has been reached, then the professional signs the offer letter. Generally, the company will as well. And then at that point, the company will then usually prepare an actual employment agreement with the binding terms. So kind of what are some reasons why someone would back out after signing an offer letter? Well, the details in a contract can significantly change when they're provided more context. So for instance, if the offer letter states, let's talk about the non-compete. It may state, it's, 2 years and 10 miles from your primary practice location, or in sales from your sales territory or something like that. And then when you look into the agreement, it may be much more kind of prohibitive in the fact that you can't not only work in your specialty, which are most of these work, but you can't work at all in sales in this area. So, obviously if you're, selling software or something like that, then normally non-competes would apply only to software. So you could switch industries for a brief period of time and then come back if you wanted to. However, if the language just says you can't work in sales in this period for that, within the 10-mile radius or something, well, that could substantially change the job. Or perhaps if there is some kind of commission-based bonuses, it may state if the contract's terminated, the professional won't receive any of those bonuses if they haven't been paid out. And so someone could work for an entire year, earn bonuses, and then maybe leave in month 10 of the year, something like that. They get nothing as far as bonuses go. So these are like a few reasons why someone would be okay with an offer letter and then maybe not okay with the employment agreement. Unless the offer letter has specific language stating this is a binding, document in some way, it is not binding upon the professional. So it's exceedingly rare to see an offer letter with that type of language. Generally, it's just, here's the basic terms of the employment, and then it moves forward to an employment agreement. Until the professional signs the employment agreement, it's still mostly a handshake. So, other times if someone's given an offer letter and then they find a new position that's better, pays more, whatever, then they'll say, all right, well, I want to, I'm not going to entertain this job anymore. I'm going to move out. So in that scenario, if someone wanted to back out after signing an offer letter, then you just need to cordially say, this isn't going to work out for me. I'm going to pursue a different opportunity. I appreciate the consideration. and just move on. You don't need to give any explanation if you don't want to, as far as why you're doing that. So an offer letter, a letter of intent, generally is not binding, and the professional is free to continue looking. Last consideration is obviously some bad blood may pop up after someone pulls out after signing an offer letter. As I said before, try to be professional and cordial about letting them know that you're not going to move forward with an employment agreement. However, this is business, and most businesses understand in a competitive job environment that people change their minds at times. And so I wouldn't, be that concerned about that, but it may happen. So you want to avoid burning bridges if possible. All right. Well, if you have any questions, you can always call my law firm at the phone number listed below in the description, or you can always reach us through our website, chellelaw.com. That's CHELLE law.com. All right. Thanks for watching the video.